Ms. Mallon.
SJC-10232, Commonwealth versus Blake.
Good morning, Ms. Curry.
Chief Justice Marshall, Justices, may it please the Court, I'm Colin Curry, and I represent Joseph Blake in this further appellate review of his commitment to the Massachusetts Treatment Center as a sexually dangerous person for 1 day to life. I would submit to the Court that the Commonwealth should not have been allowed to present the report and testimony of an expert witness who had not been appointed as a qualified examiner. And I understand that this Court had decided Commonwealth v. Cullen last month, but I would submit that that case was decided on the issue of whether or not the evidence allowed a rational trier of fact to find Mr. Cullen sexually dangerous beyond a reasonable doubt. There's one paragraph in that decision.
Can you just clarify for me? The big picture is the qualified examiners have to interview the person who they have to give a report on. But what about other experts who don't do the interviews, but they read all of the reports, all of the medical history? Why can't they just have an opinion as well?
They can have an opinion. The issue is whether or not it can be admitted in evidence at the trial, Your Honor. And I would rely upon this Court's decision in Poissant to say that they cannot testify in the same way that a qualified examiner does, that the statute provides for only 2 qualified examiners and whatever experts the respondent or the petitioner, depending on whether it's a 12 or 9, retains to represent them in the
Which
case.
language in the statute are you relying on to say that?
It's the absence of language with regard to any other experts. As this Court said in Poissant, the statute provides for no other examiners other than the qualified examiners and the respondents or the petitioners. It's the absence of provision for other examiners, and only the examiners that the Court appoints, the qualified examiners, or that the respondent or the petitioner retains. There's no provision for any other experts to testify in that same way with regard to providing information to the Court to assist it in the decision about whether or not this person meets all of the requirements under the statute to be found a sexually dangerous person. This Court in Cowan, in that paragraph with regard to the probable cause examiner, counsel in that case conceded that the probable cause examiner could testify. I don't so concede at all. Judge Greene wrote that the concession was well taken, and I just have to disagree with the position that the provision with regard to any other evidence in 14C of the statute would allow the probable cause expert's testimony. That case is just inconsistent with Poissant with regard to what the statute provides in terms of what examiners may testify and the absence of any provision.
Can I ask you this? Is the probable cause expert in this case was the witness you're complaining about, right?
Yes.
Is there a difference between what materials the probable cause expert has access to and what the qualified examiner will have access to, other than interviewing the defendant directly?
Yes. I mean, I'm not privy to what the Commonwealth or the Court provides. I believe it's the Commonwealth actually provides the probable cause expert, but the case law and the statute, the case law has mentioned that the probable cause examiner has less information in terms of documentation. And
Well, certainly at the time that they testify at the probable cause hearing, they surely do have less information than ultimately will be gathered during the process of examination. But at the end of that, I take it this probable cause, this expert, I take it reviewed the reports of the qualified examiners.
Yes.
Okay, so at that point had additional information.
Actually, I'm assuming that. I don't know that I know
Okay,
that.
all right.
I'm thinking from the Cowan argument that was said, but I don't know that in this case. I'm assuming that it happened.
Yeah, and I know you're referring to language, and it makes perfect sense that at the time of the probable cause hearing, the person hasn't been examined by qualified examiners. In fact, the probable cause expert that the Commonwealth calls to meet its burden usually hasn't interviewed the person at all. So there's a great deal of additional information which is gathered and which forms the basis for expert opinion at trial. And I guess my question is whether or not the probable cause expert, having then reviewed all of that material, can testify, is sort of sufficiently armed for testimony. And you're saying no, not even after having reviewed all that material, they still wouldn't be, as a matter of statutory interpretation, permitted to testify.
This court, in fact, in Commonwealth v. Connors, which is a case I'm not sure that I had cited, Justice Ireland, you mentioned that there's a difference, and in fact referred to it as an imbalance of evidence, between a records-only review, which is what we're talking about the probable cause examiner having, and testimony based on interviews, and talked about the unfairness to the Commonwealth if the respondents' examiners had been allowed to testify with regard to information they gained during interviews, and the qualified examiners who the respondent had refused to be interviewed by were allowed to only testify with regard to the records review. The statute refers to a clinical examination, and the probable cause examiner who has not had that interview did not, in this case, did not seek the interview at all, doesn't have that additional component with regard to information from the very person that they're going to be testifying to. And in fact, in some cases that I've cited in the materials, there were probable cause examiners who retracted their positions after they had interviewed. That is in Boyer, Commonwealth v. Boyer, 61 Mass Appellate 582, and in, I may mispronounce this, Sepulveda, which was the companion case to Duty, both found at 59 Mass Appellate Court 576.
So would you say, looking at the language in 14C about any other evidence tending to show that such person is or is not a sexually dangerous person, you would say that that is confined to written evidence?
Not necessarily, but
Well, wouldn't that language encompass other expert testimony? It says any other evidence tending to show that such a person is or is not a sexually dangerous person.
it does say that. But my argument is that the balancing that I'm doing here is saying that with regard to the screener or the probable cause examiner, the people who do this prior to the appointment of the qualified examiners are not provided for in the statute. Those are creations of both the court and the Commonwealth in needing to provide expert testimony in order to meet due process considerations prior to even a temporary commitment of the person that's being considered for a permanent commitment, well, relatively permanent commitment. And if the court had intended for them to be treated in the same way with regard to both their testimony and the statute, and the reports going in, it hasn't been said yet, and I'm hoping that this is not the case where it ends up being
forget what
said.
the courts intended. We have the legislature here saying, and any other evidence. And how do you read that to mean not some of the expert evidence?
Because this court has said that the Commonwealth only has the qualified experts, qualified examiners. And
For what purposes have we said that?
Well,
For the purpose of trial, testimony
the
at trial.
court has said that if the two qualified examiners who examined the, doesn't Poisson stand for the proposition that if the two qualified examiners come back and say this person is not a sexually dangerous person, the Commonwealth has no right to then go and try to find a third or fourth or fifth person
or sixth
who
or
would-
seventh or eighth or ninth or 10th.
to come to a different result. But that's different from if you've got at least one qualified examiner saying this is a sexually dangerous person. I don't see that it prohibits the Commonwealth from asking somebody. They cannot require the respondent to be interviewed, but I don't see that this language prohibits them from asking somebody to do a record review and seeking to submit either a report or have that record review person testify.
The statute, the legislature provided that the testimony is to be provided by 2 qualified examiners. It didn't say that if those examiners do not agree, that the Commonwealth can bring in someone else. And the legislature could have said that. This case falls in between Plaisant, where 2 examiners found not sexually dangerous, and Lynch, where both qualified examiners found Mr. Lynch to be sexually dangerous. In Lynch, the Commonwealth, for whatever reason, brought in a 3rd, the probable cause examiner. In that case, the court said it doesn't matter because that testimony was just cumulative. Why should it have been allowed at all? The statute didn't provide for that. It didn't provide for a 3rd or a 4th or a 6th.
I take it your position is the following, that the Commonwealth has to come up with 2 qualified experts. They can pick any experts they want to pick, as long as they're qualified under the statute. And those 2 qualified experts examine a respondent, right?
Well,
and then, if what their conclusions with respect to whether or not the respondent is sexually dangerous, such that he should be committed for life, subject to annual reviews, is what goes before a judge. If they both say no, judge should know that, or jury should know that. If one says yes and one says no, judge should know that, jury should know that. If both say no, the 3 permutations, and that's what should be presented to the fact finder. Is that your position?
except for the beginning. It's not the Commonwealth finding the qualified experts. The statute provides that the court appoints the qualified experts, and there's a system within the Commonwealth at the present time that there's an organization. It's not
Subject to that correction, which I recognize, yes.
They're not the Commonwealth experts. They're the court's experts. They're testifying before the court. The Commonwealth is allowed to present them, but they're to assist the court in making its determination.
I understand, but is
Other
it
than
is it
that-
not the practice that the Commonwealth suggests these two qualifying experts?
And
As
other
a
than that,
general matter, they suggest that the court appoint these 2 experts. Am I correct?
Yes.
So as a practical matter, the Commonwealth comes to the court and says, I would like you to appoint these 2 experts who are qualified for purposes of 123A to examine this respondent, correct?
I'm not even sure that the Commonwealth has anything to say about who they'll be.
Okay.
I don't know about the process. I thought that it was something out of...
But in any event, 2 experts are appointed.
Yes.
And it is your view that that's the evidence that should be submitted to a trial of fact, judge or jury, and that the respondent can produce his or her experts to challenge whether or not he's sexually dangerous.
Yes. And if the 2 qualified examiners say not sexually dangerous, it's my position that the case should be dismissed, which has happened. In some counties...
And here we had divided opinions.
And in this case, the Commonwealth was allowed to, and should have been allowed to, present Dr. Quinones, the qualified examiner who found him to be sexually dangerous, and the respondent took the qualified examiner, whose name is escaping me at the moment, and used him as one of their experts.
So it's your position that it is not necessary for the Commonwealth to call the qualifying expert whose opinion was that this man was not sexually dangerous.
Exactly.
The Commonwealth does or does not have to.
If
So
the
that the
person says-
neutral fact finder that the court has appointed, that neutral fact finder's conclusions are not brought to the attention of the judge.
The reports are both filed.
But don't have to call them as a witness.
And I don't believe that the Commonwealth is required to call someone who's going to testify against the position that they're taking. They call the person who supports their position, and the practice has been that the respondent takes the qualified examiner who does not support their position, because it's I think it would be sort of like the situation in Doobie where I think it was that case, the Commonwealth put on the negative testimony. I could have the case wrong, but there was a case where the Commonwealth put on the negative testimony and said that it doesn't matter that we don't have an expert, and try to get it through cross-examination or something, and it was just not the way that it was supposed to be.
Can I ask you a basic question? Did counsel object at trial to the testimony of this probable cause expert, Dr. Rose Weirs?
Not as to the issue of whether she should have been allowed to testify at all.
Thank you.
And how do you square your position with this language in 14C?
Based on Poissant, that there is no provision for any other expert other than the qualified examiners and those retained by the respondent or the petitioner. And is not, there's cases, McCool and McVart, where the court said that that's not to be a catch-all that's going to eliminate all rules of evidence, and I'm not sure that the rules of evidence trumps this court's position with regard to the qualified examiners being the only experts that are available to testify to aid the court in these situations.
Thank you, Ms. Coey. Mr. Greenbaum?
Good morning, Madam Chief Justice. Good morning, Justices. Stephen Greenbaum for the Commonwealth. I'd like to respond to a few questions that were asked regarding the appointment of qualified examiners. The Commonwealth has no involvement in the appointment of the qualified
None
examiners.
at all, so it doesn't have...
The qualified examiner, the treatment center has a contract with a private company. When a person, when probable cause is found, that private company
Thank you.
assigns two people independent.
Independent.
Commonwealth has no control over who's assigned as a qualified examiner.
Okay.
Also, and it's been mentioned, the notion of what information is before the expert who testifies at the probable cause hearing, the so-called probable cause expert, not at least the practice in our county, I don't want to speak for other counties, pretty much all the information that is going to be available to the qualified examiners prior to any examination or interview with the respondent, all that information has been gathered and is presented to the Commonwealth's expert prior to the probable cause hearing. So it is virtually the only information, speaking for our office, the only information that an retained expert does not have at the time of the probable cause hearing is whatever information might have been gained by an examination by the qualified experts, either through an interview or if they perform any psychological testing.
And
Why is that
prior
so?
to the witness testifying in this case, Dr.
Rouse Weir.
Rose Weir, did she have access to the qualified examiner
Yes.
reports which were filed with the court?
Yes, if we are calling the expert who happened to testify at the probable cause hearing, which is usually the case, there's at least 6 months to a year before that. And yes, any other information that has come up through qualified examiners or any other source we provide to our expert
And
before she testifies.
Okay, and is Dr. Rose Weirs also qualified to be an examiner under the statute?
She was at one time a qualified examiner. The only part of the definition that I'm not sure she falls under is that the definition in the statute says you have to be designated by the Department of Correction as a qualified examiner. I'm not sure that she still retains that designation, but I believe she may still retain that official designation as a qualified examiner.
Well, she was referred to. She was referred to both, I think, by the trial judge and by...
Yes, then she probably retains it. She is not one of the people currently under contract to regularly do the examinations at the treatment center, but she is designated.
If you have another expert in addition to the QEs, why is it the practice for the additional expert not to at least seek to have an interview with the respondent, the petitioner?
I would not suggest that that's a practice. This has been unfolding at the time. In the particular facts of this case, the respondent initially refused to be interviewed by the second qualified examiner, Dr. Quinones. I can't say I recall the facts of this particular case, but sometimes I believe the assumption back then was that the respondent was not interested in speaking with our expert. Respondents sometimes request to be interviewed by our retained expert, and then we do interview. Whether or not we go ahead and through counsel request an interview is really on a case basis. And I would not suggest it's a practice. This whole area is unfolding, but it's not a practice to not seek an interview. In this case, I think the assumption was that the respondent was not interested in being interviewed.
Oh, I thought you said something about the generally they rely on the QE reports and
If they've not had an interview,
Oh,
yes.
okay,
And
all
in this
right,
case,
okay.
all I would say, they have all that information. If we have a retained expert, that person also looks at the QE reports. But if there's an interview to be had, and as this expert testified at the hearing, an interview is always welcome. Although I would suggest, if you look at the value of an interview in this setting, is perhaps overrated.
So do you take Poisson as saying if the two QEs say not a sexually dangerous person, is that the end of the matter, or you could have somebody, you just can't force the respondent to be interviewed?
All Poisson speaks to is who can examine. And Poisson specifically said by examine we mean interview.
Right.
There's nothing in the statute that says if both qualified examiners conclude, opine that a respondent is not sexually dangerous, that the Commonwealth can't go forward if it has, in fact, a qualified expert opinion.
And qualified you're using in the...
In terms of qualified by the trial judge, not a qualified examiner.
Not statutorily qualified.
Right, qualified in terms of satisfying a judge that he or she
Mr. Greenbaum, if that's the case, excuse me, when you finish, if that's the case, what's the purpose of having two qualified examiners examine the respondent?
The purpose is to require that there be an respondent, assuming that the respondent submits. The respondent does not have to submit to being examined even by the qualified examiners.
No, but what's
assuming
the purpose?
The respondent does, the purpose is to at least make available to both parties, both sides in this case and the court, a report based upon an examination and
But what's the
interview
purpose
review
of
the
that?
record.
What's the purpose of that?
The purpose is to provide neutral information, I suppose a neutral opinion for both sides in that case to assess how to approach the further case.
That doesn't make sense. Explain to me what you mean.
I'm not sure I can tell you exactly. What I mean is that at least a baseline will be that two people who are neutral parties, not retained by either side, two people who are neutral parties and who have expertise in this area will have the opportunity to interview and examine in any other way.
Yeah, but
the person in
I
case
don't
can
know.
present a report that is available to the court and the parties to then go forward with their case as they see fit.
What's the baseline, though? So that we go through very expensive proceedings, timely, costly to the citizens,
Absolutely.
taxpayers, and then just disregard them. There's no baseline. Commonwealth wants to go forward, you go forward.
That is correct.
So what's the purpose of them? If nobody takes them into account, they're not introduced in evidence at the trial.
Yes, they are introduced. Both reports
may be.
are always in. There's never been a case where both opinions of the qualified examiner that I'm aware of don't come in. Those who opine a person is sexually dangerous are called by the Commonwealth. Those who opine a person is not sexually dangerous are called by the respondent. I'm not aware of any case.
But
where a
nobody
qualified
has to do that.
Excuse me?
Nobody has to do that.
That's correct.
Do the jury instructions that are given put the qualified examiners in a different position, sort of say these are the neutral people appointed by the court and da-da-da-da-da, or do they just sort
This
of
was
say...
a bench trial first, but I'm not aware, when we've had jury trials, I'm not aware of an instruction that puts them in any special light. I would point out in terms of what the legislature intended in terms of the statute now, in the prior version of the statute before it was repealed, Section 5 that has been repealed had provisions that said, there were qualified examiners under the old Section 4. Under Section 5, it said specifically, if the report of the qualified examiners does not clearly indicate that a person is sexually dangerous, basically, then the person went on with their prison sentence. This was when the determination was made at the beginning of a sentence. Back under the old statute, the legislature specifically gave the qualified examiners a gatekeeper function. If they didn't clearly indicate SDP, then there was no hearing, a commitment hearing. This new version, they do not have that provision. I would say, therefore, the legislature is well aware and well capable that they could have had a provision like that under the new form of statute, whereby if both qualified examiners opine not SDP, then the case would have to be dismissed. They did not put that language back in the statute this time around, which would indicate whatever the ultimate purpose of qualified examiners was intended by the legislature, it was not intended that they serve a gatekeeper function whereby if they both opine not SDP, the Commonwealth is barred from preventing an expert who does have a valid and credible opinion that a person is sexually dangerous.
Mr. Greenbaum, I wonder if you could help me with this. It's perfectly clear, both from the statute, the language of the statute, and the decisions of this court, that the one thing that we have said is because there is such a significant liberty interest at issue here, speed is of the essence. So deadlines have to be met. And 14A provides for a trial, that a trial by jury be held within 60 days. It doesn't provide for a bench trial, but you can waive that. In this case, there was a very lengthy delay before the judge issued his decision. Would you agree with that?
Yes.
What would you suggest we do to make clear to judges that they should not spend months and months and months and months with matters under advisement?
What the Commonwealth is suggesting, and what we did suggest, is that I think it has become a practice in bench trials that judges issue rather lengthy findings of fact and conclusions of law and conclusions where Section 14 calls for a proceeding much like a criminal trial with a determination beyond a reasonable doubt. I believe that a judge should, as soon as possible, as he or she is right, announce a verdict, essentially. I find the defendant SDP sexually dangerous. I conclude the person is not sexually dangerous. And if the judge intends to make written findings, issue those when they're completed, but that the ultimate determination, that basic decision, is this person sexually dangerous or not, I would gather, I don't know, I can't vouch for what the thought process was of this judge. We certainly assumed that and hoped that after 14 months the judge was not going to issue findings and find, oh, well, I find this person not sexually dangerous. I mean, the assumption was he had made that decision and was just taking time to write complete findings.
Has the Commonwealth asked for that relief in any cases, at least from your office, to your knowledge? Ask the judge to issue a verdict with an opinion to follow?
Not in this case, and I can't answer whether we have or have not in other cases. I believe the practice has pretty much been in bench trials that at the conclusion of it, the judges issue written findings, and we really don't know the decision until those complete written findings and decision
Do you think
are issued.
if you have a delay of this length or longer, would it be appropriate to say to the, and assuming obviously that the result is that the judgment is that the person is a sexually dangerous person, would it be fair or appropriate to say you should start again? I mean, that he has a right not to be designated that, but to go back and, if he wanted, have a new proceeding?
I'm not sure.
Well, in other words, I guess what I'm saying is, rather than have the status as a sexually dangerous person and then have the right to seek relief under Section 9, whether he would be better off to not have it been adjudicated if it is so long. In other words, he's been injured by that time, and to have a fresh start at it, if he chose. I mean, he may not choose.
Well, I don't think so. If you could show
Well,
that
how does he get
the
an
injury
annual
from delay somehow affected the ultimate decision. In this case, this particular respondent has already had a Section 9 hearing, a discharge hearing, prior to this coming here.
Did
It's still
the
been found to be
defendant
SDP.
file any kind of motion during the 14th?
Yes.
Yes, indeed, he did.
Yes, he did in
And
this-
he approached the Chief Justice for Administration and Management, and in fact, did, I think, everything that could reasonably have
Yes,
been done.
His counsel filed a motion requesting requesting judgment under the civil rules several months later. I know the respondent himself wrote letters from the treatment center.
What would you say about a rule, and I realize it doesn't affect the Commonwealth so much, it affects the judges, but if we were to adopt a rule in saying that the decision should be announced within 7 days of the end of the trial, and then an opinion written within 30 or 60 days thereafter?
I think that would be fine. I would leave it at a decision should be announced within 7 days. I'm not sure that there need be a written opinion.
A written decision, if any, should be...
Written decision, if any, yes.
If any, should be with...
I believe these judges should treat this much like they would treat a criminal bench trial.
Well, but if you look at the findings in this case, they're very helpful, and they're kind
Yes,
of
they are.
important.
But it's not
An
just that,
analysis
but-
of the expert testimony, what was, what the judge credited and weighed. I mean, it's very helpful on review to have that.
Right, but it's a civil proceeding. I mean, it seems to me under, I think it's Rule 52, you have to have findings. It's not a jury trial.
Well, but the civil rules expressly don't apply to SDP proceedings, and we've got this, the actual Section 14 hearing is the rules of criminal evidence apply. It's unclear exactly where this, it is a hybrid between where it's got
What's the standard of review? What is the standard of review for failure to object to the admissibility of expert testimony? Is it waiver, or is it
it's
substantial risk?
Well, I've assumed that it's substantial risk of a miscarriage because the rules of criminal evidence apply, and assume that in terms of where the liberty interest applies here, that the similar standards would apply in these sorts of cases. But,
is that true in civil commitment proceedings also?
it may be, and I don't recall where I cited to that in my brief in adopting that standard. I may, in fact, have referred to a 123A or 123 case, but I don't recall offhand.
Certainly, I take it, forgive me, Mr. Greenbaum, and I should know this, if the fact finder determines that somebody is not sexually dangerous, what are the Commonwealth's rights in those circumstances?
I believe we might have the right to appeal.
I just don't know. I mean, I was not saying, this is not an exam question. I was trying to think of...
I'm not aware of anyone having appealed a determination that someone
No, I'm
is
not either.
SDP.
I was trying to think that at very least, to follow up on Justice Cowan's suggestion, certainly if the judge determined after bench trial that somebody was sexually dangerous, presumably the respondent could ask for factual findings. I mean, one way to do this is to say, and the respondent may not have an interest in challenging the judge's determinations, so that it may be possible, I don't know, to tweak it slightly, that says that verdict should issue within the 7 days, and then at counsel's request can ask for written findings, which will be submitted within 30 or 60 days, whatever we decide. I mean, I'm trying to think of who's, when we start making these...
Yeah, and I believe the reason you get those, the volume of records that are submitted with these trials are large. It's
I
not
understand
just,
that.
It is a huge stack of records, and I believe that the judges want to go over everything that the experts
What do
have
we do
relied
with
on.
juries? I mean, when you have the qualified expert reports submitted, I mean, I understand that in this case, in fact, both sides called the respective QEs to testify. The Commonwealth called the one who said he was sexually dangerous, and the respondent called the one who said he wasn't.
Yes.
Is that generally what happens? Is there any...
I'm not aware of it being, of their qualified examiners, I believe, are always called by one side or the other, and typically, the experience in our county, and as I'm aware from other counties, there's usually one or two or more other experts for the respondents who are retained, and the Commonwealth, depending on where the QEs came out, perhaps the Commonwealth will be offering perhaps its own retained expert as well. There's usually more than just the two qualified examiners who testify in these cases.
Thank you, Mr. Greenbaum.